TCC Judgment 111 Champan 20, 2022. Case on citizens standing in administrative litigation over foreign spouse resident visa. Hey notes. In this judgment, the Taiwan Constitutional Court, hereinafter the TCC, upheld the constitutionality of the resolution of the first joint meeting of the Supreme Administrative Court of August 2014. August 12, 2014. The TCC pointed out that the resolution only barred the Taiwanese nationals from filing an action for administrative act to request the issuance of their foreign spouses visa with the court. The TCC ruled that so long as the Taiwanese nationals are not excluded from filing action for revocation against their spouses visa rejection, the resolution did not violate their right to marriage and the right to institute legal proceedings. Background note. In 2014, petitioner asks a Taiwanese nationals, hereinafter acts of this case, and the Vietnam national Y, hereinafter Y, got married and registered in Vietnam. Later that year, the couple gave birth to a child in Taipei. Y applied for the authentication of their marriage certificate and the issuance of a dependent visa, resident visa to Taiwan Economic Cultural Office in Vietnam, Ministry of Foreign Affairs, hereinafter the office. Y's application for visa was rejected by the office with an administrative act for the reason that the office deemed S and Y to have given faulty or inconsistent statements on the important effects of their marriage. S and Y each filed for administrative appeal. Their cases were consolidated and rejected together by the executive yuan. S later filed an action with the court asking for the revocation of the Office Administrative Act and additionally the issuance of Y's dependent resident visa. As case was discharged by final decision of Taiwan, as case was discharged by the final decision of Taiwan High Administrative Court, Judgment 104 Su 190, 2015. The said decision, citing the resolution of the first joint meeting of the Supreme Administrative Court of August 2014, August 12, 2014, and on account that S is neither the applicant of the said resident nor the party of the Office Administrative Act, therefore does not have a basis of claim or interest in the case, rule that S lacks legal standing in the case. Petitioner X filed for constitutional review, arguing that the pertaining resolution infringed the petitioner's right to institute legal proceeding, right to marriage, and the right to family life guaranteed by Articles 16 and 22 of the Constitution. Summary of the judgment holding. The resolution of the first joint meeting of the Supreme Administrative Court of August 2014, hereinafter the resolutions, decided that when a foreign spouse applicant was rejected his or her resident visa application by the competent authority, said applicant's Taiwanese spouse shall be dismissed by the administrative court when filing an action for administrative act to grant the visa application. This resolution only decides on the legal standing of filing action for administrative acts in litigation regarding resident visa application cases, denying the legal standing of Taiwanese nationals in filing action for administrative act in their own names. However, the resolution does not rule out the possibility of said Taiwanese nationals on the account that their freedom in managing their future marital life with their foreign spouses has been restricted, filing action for revocation with the Administrative Court under Article 4 of the Administrative Litigation Act. Within said confine, the resolution is not in conflict with the protection of the right to marriage and the right to institute legal proceedings enshrined in Article 22 and 16 of the Constitution.